In this presentation, we will discuss restrictions on non-audit services to attest entities. In other words, if we're a CPA firm, a public accounting firm in the process of performing an audit or some other attest services where we are providing an opinion on something, say like the financial statements, we want to consider those items that are non-audit information or non-audit activities that could compromise our independence. And this is going to be something that's really important with a CPA firm, with an accounting firm, because a lot of these types of things are things that you would think would kind of naturally go together. In other words, if we were a public accounting firm, we would want to do some of these things because they naturally go along with the audit process. But we need to restrict ourselves in some ways on the type of non-audit engagements that we have with the entity, because it causes problems with relation to independence of that entity, and we'll discuss that more as we go. Restrictions on non-audit services to attest entities. The AICPA Code of Professional Conduct restricts the kinds of non-audit services that can be provided to attest entities. So there's going to be restrictions on, again, the non-audit services that are provided to attest entities, those that we're performing things like audits for, because of this problem with independence, with other types of services that could be given to them. The SEC has restricted independence rules for audits of public companies that are more restrictive. So you can think of this as a kind of a hierarchy. We have the AICPA restrictions, and then when we consider public companies, the SEC has more stringent restrictions. And you can think about this as these restrictions have grown, of course. The AICPA had the restrictions in place when problems happened, when it was perceived that more restrictions were needed. Then the SEC put those in place, generally applying them to larger companies, because the larger companies, of course, are going to be subject to more regulations, oftentimes given the nature of those companies. In particular, the nature of larger companies doing business or getting investments directly from the public. So given the fact that the investments are coming directly from the public, that's one reason, of course, that you need more regulations typically for these larger entities as well. SEC and PCAOB independence requirements for audits of public companies. 4 principles of audit objectivity and independence. So these are going to be the overarching principles. Auditors should not audit his or her own work. So as we consider the specific rules, this is going to be the overlying kind of principle that we're thinking about. And obviously, if you think about that overlying principle, you're going to say, well, what kind of things should the auditor or the CPA firm not do in order to avoid the auditor auditing their own work? Obviously, if they actually did some of the accounting work or was putting in place the internal controls, actually building them and putting in place the internal controls, then obviously when we perform the audit, we would be auditing our own work. So again, you could see how that natural loop would happen within the CPA firm. We're working with a company. Obviously, we know a lot about internal controls. We audited their internal controls. We know exactly what their weaknesses are. It would be natural then for them to contract us and us to say, yeah, let's build the internal controls and then we'll implement them possibly. Well, that could be a problem, because next time when we do the work again, we're going to be auditing, in essence, our own work possibly in that place. And that could be an area where this is a problem. So you can see, again, it's natural for the CPA firm, these type of engagements other than the audit engagement, to go along with the type of work that we're doing within an audit. So it's natural for a CPA firm to kind of want to do these other type of engagements and see that it could be a beneficial engagement to do them within an organization, but it compromises independence. It compromises the value of the audit, and therefore we need to not do some of these types of engagements. Audit should not function in the role of management. So obviously, if the auditor is functioning as a role of management within the organization, they have a significant influence of it. And again, if we have significant influence of the decision making of management, we're somehow invested in it, and we're probably auditing to some degree our own work once we do the audit. Auditors should not serve in an advocacy role for the entity. So if we're acting as an advocate for the entity, in essence, we're basically endorsing the entity in some way. Well, if that happens, we could be invested in the entity emotionally, at least, as we advocate the entity, and in appearance, that could also compromise what others might think of as independence, which could compromise the value of the decision or opinion that we're giving on the financial statement. Auditors should not have a mutual or conflicting interest with an audit client. So if we have some kind of mutual interest with the audit client, then of course you can see how that could compromise the independence or the appearance of independence. If we have a conflicting interest with the client, you could see how that could also cause a problem. If we're both, for example, having a mutual interest in some third thing, then it's the case that we want the company to do well, and that could compromise independence. If we have a conflicting interest, for example, if the client is suing us for some type of thing or something like that, then you could see how that could cause a problem as well within the audit, because no matter what the audit opinion is, under those situations, you could see how the independence can be questioned, even if it's not really, even if we acted in due diligence and did all the work we could see how the independence can be questioned in that situation, could compromise then the value of the audit opinion. Categories of prohibited non-audit services. So these are the types of things we want to basically think about in terms of those audit clients. So if we have an audit client, we have to think about these types of things that we have to restrict ourselves from doing because they could compromise independence. One is the bookkeeping. So obviously if we're doing the actual recording of the bookkeeping, then that could be a problem because we would be auditing our own work possibly as we go through the audit process. Financial information system design and implementation. So notice that if we have the financial information system and we basically design it and implement it, again, that means that we're going to be auditing our own work in essence. These are two things that are just natural for a CPA, for an accounting firm to think about. It's another service that they can provide. It's in their wheelhouse of types of things that they do well, but there are things that could compromise independence. So that's why there needs to be special guidance with regards to them and special consideration with regards to them if we're doing audit engagements for a client. Appraisal or valuation services, so what appraisal services, because again, if we do an appraisal on the valuation of certain types of things, and then we do an audit on the value of that type of thing, if we had an appraisal of what their inventory is worth, then we audit what their inventory is worth. We're basically testing our own thing. Actuarial services, again, actuarial services basically are oftentimes employed to value types of things. And if we do that, then we're going to be testing those types of things, which will be testing our own work in the audit process. Internal audit outsourcing services, management functions or human resources. So anything that's basically controlling, the management function, then again, seems like we're kind of auditing our own type of situation if we have a controlling situation with the organization that we are then auditing. Broker or dealer, legal services, and expert services. So these are all types of things that if we have an audit engagement, we need to be careful of. And you could see how they all line up to those general principles. In essence, a lot of these things would be involved in, if we were to do them, then we would perform an audit, which would basically be auditing as providing a judgment on the thing that we basically did, possibly a lot of times. And that would compromise the independence of the audit decision. SEC and PCAOB independence requirements for audits of public companies. The lead and engagement review partners are limited to 5 consecutive years. So there's actually a limitation on the lead engagement review partners. And you can see why this would be beneficial. You can also see why this didn't really happen before that time period. Note that if you're thinking about the type of organization that typically is an audit firm, you can think about it basically as partners that have their own clients oftentimes that then have the staff, and the staff is going to be kind of like the overhead that works on particular clients. So it was quite often the case, and with small firms it may still be often the case. With these, we're talking about publicly traded companies where one partner would have an individual client, an audit client, that they would always perform the audit on over a long period of time. And you could see why it would be more beneficial in terms of the value of the audit if you actually had someone else leading the audit engagement from time to time, taking over the audit engagement, because then you get a fresh pair of eyes on it and you get more of a, that kind of separation of duties, a double check on the information as someone else goes through the audit process as well. So this is something that seems reasonable, but because of the structure of a typical kind of CPA firm, not something that was typically there before a rule such as this is put in place. A 1-year cooling off period is required for employees in a financial reporting oversight role who previously worked with the CPA firm performing the audit. And you can see what this is getting at. This rule is getting at the fact or the problem in that a CPA firm, especially large CPA firms that work for publicly traded companies, then the people that work at the CPA firm often then go work at the CPA firm and then go and work at the company, possibly from the CPA firm. And as that continually happens, you can see that there's this kind of connection between the reviewers, the CPA firm, and the company now that could have people that previously worked in the CPA firm that are now in lead roles within the organization. So this is an attempt to address that issue. Then we have a firm is not independent if an audit partner's compensation is based on selling engagements to that client for services other than audit, review, and attest services. So once again, a firm is not independent if an audit partner's, the top people, the partners, compensation is based on selling engagements. So their compensation is based on the selling of engagements to the client for services other than the audit, review, and attest services. So in other words, if the compensation is primarily based on these other types of services, the idea there is that it's going to compromise the opinion of the audit engagement, because the partner doesn't want to cause a problem with regards to the audit engagement because they're getting compensation from these other areas, and that you could see how that could be a problem with regards to independence or the compromisation of the audit opinion.